Well, very interesting times in the country, I assure you. And if I ever get tired of saying this, remind me that I begged for more interesting political hours or political seasons in our darling nation, Nigeria. Very interesting times. The Supreme Court has ruled that the president has constitutional power to declare a state of emergency in any state to prevent chaos or breakdown and law of order, and can suspend a sitting governor. Now, this ruling has caused a lot of rancor. A lot of people are questioning, does it have the powers to do such? Others are saying, well, I mean, if the Supreme Court has said it, it's precedence, and we're going to move on, moving forward. Now, this comes following, the whole situation that happened between Fubara and Rivers State earlier in the year. To discuss this, I have two very, very nice gentlemen who have proven to me that they're boys at heart. Just now, I'll tell you the story later, but let's get into serious political matters. Malam Okafo, good afternoon.
Yeah, good afternoon.
And Mr. Philip, having a good day?
Let's say you're welcome.
You're welcoming me. Okay, thank you. Thank you, Philip. Thank you, Philip. Okay, let me have your standpoint. What was the first thing you thought when you saw this story?
My happiness was that there was a dissenting voice. So, I would have been very, very much disappointed if it was a unanimous decision. It means that there is a justice, of Supreme Court that is actually thinking like some Nigerians, which is Justice Obande Winner. Well, that was the dissenting voice. So, but be that as it may, the Justice Idris, the judge, the alleged judgment, was categorical in making it clear that there are some things in Section 305 of our Constitution that is not very clear. He went this way. He said, Section 305 was not specific on the nature of the extraordinary measures that the president might use, thereby granting the president the discretion on how to go about it, in either removing the governor or not, while declaring state of emergency. Nobody in Nigeria doubts the fact that the president has the right, to declare state of emergency. But whether the governors or any elected political officer should be removed is what is actually in question. Now, we are worried that what the judge himself has said is ambiguous, is now being, applied in place of Section 188 of same Constitution that talks about how governors can be removed. One of them, maybe death, resignation, impeachment, and when the president declared state of emergency, was not listed as one of those conditions where governor can be removed from office. So if it was anticipated that when the president declared state of emergency, that the governor will leave office, vacate office, that condition would have been included among the conditions where governor might not be functioning in the office. But be that as it may, yes, you can never say every law is watertight. None is watertight. But now, looking at it from the moral point of view, what is ambiguous that is not clear, and this is a practice of democracy, not monarchy. You are rather taking sides with where the president, only one man, have to exercise discretion over elected people. What is the reason for state of emergency? It's simply to restore law and order. Law and order can be restored when the governor is not necessarily removed. They even acknowledge that even in that when you remove the governor from office, it's going to be for a limited time. That limited time is also ambiguous because you didn't say
how long.
You see, the say 6 months as the maximum time in the Constitution. So they have just introduced ambiguity upon ambiguity. But be that as it may, the law of the Supreme Court is final, and we have no other ways around it.
Now, Philip, over to you. This definitely gives the president much more power, do you think? And do you think that it is healthy power to put in the hands of a president? More power,
I think otherwise. There is no much additional power to the power the president has already had. The president's power is derived from the Constitution, and it remains so. Because if this issue of the Supreme Court deciding or not deciding is, like I said in my previous edition, that look, this judgment is clumsy. You cannot, rely on it entirely. Because if you look at that judgment from what we have seen, the extract, because we have not seen the entire judgment, it says that the lead judgment said at some point, at one breath, he structured the matter. At another breath, he decided on the merit of the case. At another breath, he dismissed the case. Now, coming to the issue of the Constitution, especially Section 305 and Section 188, we have to open our mind to these sections. Section 188 talks about how you can remove a governor from office. It's either by death, by impeachment, or by resignation. But what is envisaged on Section 305, it is not removal. It is suspension of the government for a period. So if you agree, if you look at the dissenting judgment, that the president has power, to call for a state of emergency, but he does not have such power to remove, the elected officer from office. All right, and we're talking about Rivers State. The president never removed; they were suspended and they were reinstalled. We need to get it clear. The word remove and suspension
are two different things.
They are two different things. So when you are talking, you see, there is no relationship between Section 305 and Section 188, because 188 is exclusively on removal, permanent removal from office. While Section 305 envisages where there's breakdown of law and order, and the state can no longer, fend for itself. The federal need to move in. For that period, the federal will move it to restore law and order. These people need to give way so that when law and order has been restored, they will come back to their seat. And that's what has happened in Rivers State.
Well, what does suspending this, so let's leave the removal now. We know it was a suspension, but how does it affect, the mandate of the people? Because these officials are elected. They're not appointed by the president.
How does it affect the mandate of the people? When there's a breakdown of law and order, the mandate of the people become nothing. That is why it's a state of emergency. These are not normal. Things had gone out of hand. We need to restore order. You understand? So the people who were supposed to be in charge, they lost control, in quote. So a higher power has come to restore, law and order before these people can take control. And that's what happened in Rivers State. So, you see, in as much as I'm not agreeing with the judgment of the Supreme Court, right? But in looking at the Constitution and the decision, you can see that there's some, element of, reasoning in it.
Now, over to you, Malam.
Can I read the section 305?
You want to respond to that first?
No, not respond with general education. Let's read the section 305. Issue of suspending governor is not even included at all.
In 305.
Whether suspend, removal, anything. Okay. Let's list 305. Okay? So the president shall have power to issue proclamation of state of emergency only when A, the federation is at war. A, the federation is where? At war. B, the federation is in imminent danger of evasion or involvement in a state of war. Then C, there is actual breakdown of public order and public safety in the federation or any part thereof, which might be Rivers State. You understand? Thereof, to such extent as to require extraordinary measures to restore peace and security. D, there is a clear and present danger of an actual breakdown of public order and public safety in the federation or any part thereof, requiring extraordinary measures to avert such danger. E, there is an occurrence or imminent danger or the occurrence of any disaster or natural calamity affecting the community or a section of the community in the federation. So this is not only about politics, so that we understand what is envisaged here. It's about deployment of bigger power to restore order. That is the only principal thing that is the president is coming in for, is to restore law and order. And he said on this one, there is any public danger which clearly constitutes a threat to the existence of the federation. G, the president received a request to do so in accordance with the provisions of subsection 4 of this section. Now, look at the subsection 4. The governor of a state may, with the sanction of a resolution supported by 2/3 majority of the House of Assembly, request the president to issue a proclamation of state of emergency. Let's take time. It's too long now for us to take the time.
To break it, dissect it word by word. Well, yes, we've had situations in other climes.
Or even touching the governor. There's nothing like that.
Yeah, but we have had situations in the
they're
country
hiding
where
under the extraordinary measure, which is being even lifted.
You see, I think we have always overflogged this issue. We know as a fact that the issue of emergency in Rivers State was not, and it will not be in accordance to the laws of our land. First and foremost, when the president declares state of emergency in Rivers State, he requires a 2/3 majority of the National Assembly to ratify his action. That was never done because it is not done anywhere, and it will not be done in any way that a 2/3 majority could be reached by voice voting. But as per the interpretation of the law by the Supreme Court today, you see, I can't help but to agree to a large extent with the Supreme Court because the sessions are two different. Section 188 is
no. Let's remove section 188. Let's concentrate on
section 305.
Yeah.
You see, if you look at the section again, this section 305 again, you can see that the declaration of the state of emergency in Rivers State was mischievous because the reason the section gave the president, there were none of those ingredients that require of law before you can declare state of emergency. If we're talking about this one, fine, but the issue before the court, that's what is paramount. What is the issue before the court? Is not a Father Christmas. The court will not give you what you do not ask for. What was the plaintiff asking the court to do? If the court is the plaintiff is asking the court to say whether the president had powers or not, the court has said the president has power.
Well, do you think that in further litigation or in trying to amend the constitution, this can be revisited in the future? This judgment,
you see,
ruling,
any judgment of Supreme Court cannot be upheld until after 10 years, or it has to be legislated upon by the National Assembly. That's the only way you can.
You see this
so this law will remain as it is for the next 10 years. Minimum. That's the law.
Minimum.
Yeah, well, if you look at the electoral status if you look at the timeline, the electoral timeline of the country,
10 years
is a very short time. Because we have 6 more years, and then 4 years, which is another.
And that 10 years, it's not automatic.
It's not.
If during that after the 10 years, if a matter like this does not come up, the Supreme Court will not have the chance to adjudicate on it. So it remains the law until such matter come before the court. And if any matter comes before the court within the period, it will be the precedent the court will stand upon.
So should Nigeria's federal should governors be worried about their vulnerability now to the federation?
Yes.
Should they be worried that at any point the presidency can just swoop in and take over?
Yes, they will be worried.
They should be, or they would be.
Yes, every governor will be worried, and every governor have to, I don't know how to use this language, how to be in the good book of the president. Otherwise, state of emergency can be declared in your state.
So this is where I have a problem. When you say that they should be in the good books of the president, is this now going? How does this affect our democracy?
That's the problem. Now the governors don't have a choice than to make the political choices of the president. He doesn't look it easily, but that's what it is, because truth remains that if this of Rivers State can pass through, any other one can pass through. You understand? The danger need not be there. You just need to say, there is crisis. What is crisis? The worst case happened in Lagos State. Obasa said he was the speaker. Miranda said she was the speaker. At a point, police chased all of them away. There was no speaker. That is a stalemate. The government wasn't even functioning. That was a clearer ground for anything that sounds like state of emergency to have been evoked, but it never happened, simply because the Lagos State is the state of the president. But now nothing like that was happening in a Rivers State. They had presented budget. Fubara was ready, going. He went there. The state people were not there. There's nothing that rose to that. So any governor now have to remind you. Fubara said it was Tinubu that saved him. All other governors will queue behind that. Whichever political parties that brought you to the office, when the president emerges and is not from your party, you have to lick the boot of that
Well,
person.
again, how does a person save you from a quagmire that the person put you in the first place? You know, that is a question for
That's
another
politics,
day.
and that's also what the Supreme Court has made us believe, that when you say extraordinary measure, it means that your power is unlimited. That's what they are saying, that the extraordinary measure that is expected of the president does not anticipate that the presidential power is limited. So there's an absolute power there, which I think the law did not anticipate.
However it is that this runs, I have one thing to say. Security, democracy, and power, they've all met at a T-junction, and it's called the justice system of the Federation of Nigeria. What happens in the future, we look onwards, but for today, one thing I'm very certain of is this is where we're pulling the plugs and drawing the curtains on this episode of the program on alternative mindsets. Have a very, very beautiful day moving forward.